Good afternoon. Call our first case of the afternoon, People versus Boven. This is a 15-minute mini oral argument on the application. You both have 2 minutes of a free fire zone. You may reserve time for rebuttal, but we ask that you keep track of your time, and you may begin when you're ready.
Good afternoon. May it please the court, Jane Carver here on behalf of Mr. James Boven. Mr. Boven was sentenced under a guideline range that started off disproportionate due to the scoring of his past crimes all the way back to 1988. This was despite him having a 17-year crime-free period between the instant offense and his last committed offense before those 17 years. Mr. Boven was sober and law-abiding for those 17 years, and he was not awarded any benefit for that under the sentencing guidelines. The sentencing guidelines were enacted as a guidepost for proportionality in sentencing. And under those guidelines, PRV 5 for misdemeanors, the prior record variable for misdemeanors, the legislature specifically took away the crimes against the public welfare, such as the disorderly conduct that Mr. Boven was convicted of in 2011 that interrupted that gap in his criminal history. So his guideline range ended up being double that of what it was at sentencing. His guideline range was 72 to 120 months, where it would have been a more proportionate 36 to 60 months. So we're asking you to overrule People versus Butler, decided by the Court of Appeals in 2016, which the result, their decision results in a scheme of sentencing that results in disproportionality for the defendants such as James Boven. The reason for this is that the 17-year crime-free period is an indicator that he can have more crime-free periods in the future. And the other reason is that the legislature decided when it took away the crimes against the public welfare and indicated that only misdemeanors that had to do with drugs or weapons or property offenses or crimes against a person should be scored or worthy of attention under PRV 5. So the majority's opinion results in something that doesn't make sense as far as what the purpose of the sentencing guidelines is. And their reasoning also doesn't make sense because they're basically ignoring the fact that we're talking about the sentencing guidelines and prior record variables when the statute for the 10-year gap instructs on how to apply it. So they say look to the last conviction, and if there's not 10 years in between this conviction and the last conviction, then use that conviction for scoring. And you can't use a conviction unless it's usable, unless it's scorable. So any kind of misdemeanor that is not scorable anyways wouldn't be counted as a conviction, just as a plain language. Read together with the rest of the guideline manual, of course, but you don't have to go very far of a stretch of the imagination to know that they mean any scorable prior offense, criminal offense.
Counselor, what do we do about the fact that the statute requires that both HIDA assignments and expunge convictions can be counted? You know, those are both things that the whole point is to sort of wipe your record clean, allow people a clean start moving forward. Why wouldn't then a more minor conviction also count?
Well, those are erased with the thought that that defendant will prove themselves to be a law-abiding citizen and go forward from there without any further convictions. And the sentencing guideline, the legislature specifically, wrote that in there because it's not an obvious thing. I think this issue is a little bit more obvious that if PRV 5, if something's not worthy of being scored for PRV5 and not an indicator of future crime behavior, criminal behavior, then of course it's not worthy of erasing someone's 17-year history of being crime-free. I mean, if you score for PRV5, his guidelines might go up a little bit, but this is a substantially worse effect than it would be if it was just scored for PRV5.
So what about the argument that the prosecution has that a lot of these offenses are pled down? So the original offense was more severe, but a plea deal was cut. So what shows up on the record is less than what was, originally charged. Arguably, maybe could have been proven. We don't know. What do we do with that?
Well, that's a lot of uncertainty, but I think a lot of the pleas that I negotiate every day, it's because they're reduced because they deserve to be reduced. Especially up in Emmett County, it's a smaller county. I don't think they dismiss assaultive crimes on a regular basis and move them down to disorderly, and I do know the facts of that case, and it was a deserved reduction to disorderly conduct.
Okay, last question. What about, what if there were like 5 minor misdemeanors? I mean, could there just be an endless number and they don't get scored?
Yeah, I mean,
I know here it's just 1, I understand that.
Right, but I mean, those minor misdemeanors they're so minor, and a lot of them are driving offenses, so you get pulled over, you might get 3 at once. And I mean, I still think that they're not indicators of a criminal sort of devious mind, if you will, even if it's like a trespassing or a disorderly conduct. It's something that when people get caught up in the criminal justice system, sometimes they have a little bit, it seems like they have worse luck than the rest of us. And to hold them to an even higher standard when they are sober and crime-free for 17 years just seems odd. When you or I would go to court and, our trespassing wouldn't count for scoring PRV5, and it would count much less so than it does for Mr. Boven and others like him. And
Did the defendant waive this issue in the lower court?
no, the trial counsel actually brought it up I contemplated filing a trial court motion, but I think the court decided at sentencing that they were scored correctly. The defense counsel I'm not sure if he objected to it, but he pointed it out that, the law right now is that, under People versus Butler, that this does count, but it's just a minor misdemeanor. And, judge, you should issue a proportionate sentence based on the fact that this doesn't count for PRV5, but it counts as far as eliminating the 17-year crime-free period.
But
And
he didn't say Butler was wrongly decided.
I'm sorry?
He did not say Butler was wrongly decided. In fact, he said he had no dispute with the application of the rule, didn't he?
Well, I think he said that, but the implication is if he's saying that it's not a proportionate sentence to sentence within the high guideline range, so in reality, he does have a problem with the opinion in Butler.
Okay. It seems to me you're relying also on Judge Gleiser's dissent in Butler,
Yes.
that we should read these statutes in pari materia. But my understanding of that canon is we only do that if any portion of the statute's unclear. And what's unclear when in MCL 777.55 it says any conviction? What's unclear about that?
I don't think it is unclear. I think they mean any scorable conviction. And I think that if they meant something different than that, then they should have said any conviction, even those that aren't scorable.
So any conviction means any scorable conviction. If it meant anything else, they should have said any non-scorable conviction?
I mean, that's how I read it. It's in the guideline manual. It's in one book. I mean, there's talking about, okay, go to the next conviction. If it's they don't say if it's scorable. They say go, if the time elapses less than 10 years, then score that conviction. They don't, but of course you wouldn't score disorderly conduct. They don't say that, but of course you don't. And so you wouldn't count it as far as interrupting a 10-year gap either.
Okay.
The reason this resulted in a disproportionate sentence is because Mr. Boven is a very high-functioning member of society. He has a skilled labor. He's dyes granite. He was sober and working hard for those 17 years. And I've been talking to his sister and his friend, and he has a supportive family. And they don't know the legal term, but their instinct is, this is like, I mean, 8 years for this? He was so good for so long, and, you know, like, it shocks them. And so I think that their thought is that if they had the legal terms, was it's very disproportionate to him as an offender. Maybe not to his offense now, but to him as an offender, it's a very long sentence. I mean, he's going to be close to 60 when he gets out, and the likelihood that he's going to be law-abiding again for another 17 years is very high, because he's proven he can do it. He's proven he can be sober, and this was due to a big life problem that he faced. He was in a long-term relationship for like 20 years, and that ended, and this is, you know, he relapsed, and this is what resulted from it. So he has a more stable life to come back to now, and, you know, of course he's, you know, over that breakup, and he knows how to stay sober. He's proven it for 17 years. And I mean, this happens a lot. It's hard to stay sober as an addict, and you have to work at it every day, and it's in a moment of weakness, like a ending of a 20-year relationship, is something that could do that. And I think the guideline range doesn't account. The high guideline range doesn't give him any benefit for his long sobriety. So many years of sobriety, I should say. The range acts as if he didn't have that at all. And the 1988 offenses don't have any probative value as far as predicting whether he's going to reoffend, as far as issuing a proportionate sentence to not only his crime, but him as a person. And him as a person is completely different than what that range is. That range is inaccurate, and the result of the Butler Court's opinion is it goes against the whole purpose of the guidelines, that it should be a guidepost for issuing proportionate sentences. And they talk about whether it's worthy or not of whether, you know, these misdemeanors are worthy of being scored for PRV 5, as far as like predictors for future criminal behavior and you know, guideposts for proportionality. And they say the legislature deemed these offenses not worthy of PRV 5. So why would they be worthy of something much more harmful to these defendants if they're not worthy of even, I mean, it might not even raise your range if you have 3 misdemeanors and then you get the 4th, and it's you know, that's the same number on the grid. So if it's not worthy of that, then it's not worthy of just obliterating his 17-year crime-free period. And I would like to save my last 2 minutes for rebuttal.
Thank you.
Thank you.
Thank you. With all due respect to Ms. Carver, I know she's working very hard for her clients, and I would never say that empathy has no place in the law, but I think when we have empathy, it needs to be directed towards more quantifiable and more to qualities that could be more easily applied. Wonderful for Mr. Boven that he has a great family and a great job, but what if he was poor and stupid and had nobody? Does that mean that these sentencing guidelines should be applied differently? I think the irony and tragedy of Mr. Butler's original contribution to the canon of our statutory construction is that it's likely his fate should never have been contingent on this argument to begin with. From the case history, it appears that there was a late abstracted misdemeanor on his record, and that should have been addressed prior to him even being sentenced. And if it was not, late abstracted, and for some reason his own actions prevented that case from resolving and closing up, then he did not have, he didn't meet the guidelines. He didn't have the end date of that prior conviction more than 10 years. And we can't let sympathy for him or for Mr. Boven dissuade us from following the law, particularly because Mr. Boven's situation cannot be considered to be a paperwork error or the fault of some data entry clerk. Mr. Boven didn't have this crime-free period. He merely had one minor crime within that period. Ms. Butler, the case was correctly decided, and I know the most incontrovertible proof of that is the fact that the legislature has now had their own almost 10-year gap to address that, and they haven't. They've been comfortable with the decision made in.
I'm sorry, but when you took the podium, you didn't, I'm unfamiliar with you. Can you
I
make your appearance on the
apologize.
record?
I got carried away, I apologize. I'm Kayla Pelter, on behalf of Plaintiff Appellee for the state of Michigan, Emmett County.
Thank you.
Thank you.
So Butler was properly decided.
Probably was properly decided. If the
And
legislature
you
did
want us
not,
to take legislative acquiescence as the basis for that they haven't done anything? There's a lot of things that the legislature cannot do, even if they might want to, because it's divided government. There's so many different things. To simply say, 10 years have passed, the legislature hasn't done anything, so this must be right, it's not something that I particularly find persuasive.
and I accept that the fact that they haven't addressed it, it could be to a divided legislature, but when we look at statutory construction, generally we are not encouraged to consider, well, maybe that word was left out because of one lobbyist group or another. Our guidelines of statutory construction are very clear. The legislature speaks and we follow it. We have, between People v. Peltola, Plutsky versus City of Allen Park, I think that Sun Valley Foods almost is a index of the rules of statutory construction. And nowhere in those cases does it say to take into consideration the fact that the legislature may have had bigger problems or in, 50% votes or an inability to come to a consensus. They're very clear that we read the language as it is. We do not insert words, we do not delete words, and that for a statute to be considered ambiguous, it needs more than the fact that a word is chosen to be used in one place and not in the other. Bailey versus United States, we consider both the plain meaning of the critical word or phrase as well as its placement and purpose in the statutory scheme. Perhaps they meant to consider what was going on politically, but I think that would have been more clear in the opinion then. For a statute to be considered ambiguous, we do need more than just the use of a word in one place and not in another. It is possible for a conviction to be, for the definition of convictions appropriate for prior record variable scoring to be different than the definition of any conviction without violating impari materia. A conviction does not cease being a conviction just because it can be used for one collateral purpose and not another. Any conviction clearly does not mean only some convictions. It is not for us, I think, to speculate on the statutory or the whatever consideration they gave. Why did the legislature want all convictions to be used for the 10-year period? Why did they want only some to be used for the prior record variable? There could be any number of reasons. Many reasons are probably documented if we go back and look at the legislative history of it. But the fact is that it was written and it was based on the older judicial doctrine of that 10-year gap. They had an original working outline and they chose to add it in as any conviction for that 10-year period and only certain for the prior record variables. I acknowledge that my briefs are essentially just a litany of the laws, the statutory construction tenets. We can go through all of those again, but from Palutsky, when analyzing a statute, the courts must presume every word is used for a purpose and may not assume that the legislature inadvertently made use of one word or phrase instead of another.
Let me shift gears, because we all read, the briefing. What is your response to Sister Council's statements about how it's odd that this is not scored in the PRV, but it would have such a drastic impact on sentencing?
I guess my response is that I don't find it odd. There had to be a bright line, and the bright line that they put in was any conviction within 10 years. Again, I can sit here and speculate on what the philosophy behind that and the goal might be, but I just don't find it odd. It may be unfortunate, but it's not odd. Any conviction, for whatever reason, they wanted that period to be completely free of convictions.
Is it safe to say that if they didn't want that your position is that that's for the legislature to fix? So that where this may be, an unfortunate situation for this defendant in front of us, that if the legislature was not intending that, where this underlying offense isn't considered for the PRV, but it is for this sentence that's before us, that they need to fix that?
Yes, and I think that goes back to the earlier question of what if it was 5 convictions or 6 convictions, all of which were minor. I think that they needed to find, I'm guessing, again, speculating, which is dangerous, there had to be some sort of a balance in order to assure some sort of reasonableness in sentencing, and therefore, so we can add points for certain prior records, but we should take into consideration the fact that a person has still commit a crime. I do think there was that's very intentional, and again, I don't find it odd. I think that there was probably some sort of meeting of minds in order to, there was probably people who wanted to see a harsher plan and guideline, no 10-year gap or only a 5-year gap, people who wanted to see, minor misdemeanors not included. Whether this is a compromise or everybody who worked on legislation and voted on it was completely of a mind is irrelevant. The language is clear. Any conviction within that 10-year period, not crime. I mean, it doesn't say anything, you're crime-free except for, it doesn't, the fact that the term prior record, and they're so carefully defined what sort of what a prior record variable would be, it's inconceivable that would have been just left out accidentally from and ignored in writing that the original statute, the 777.50, it's very over and definite that they said any conviction.
Thank you.
So, Counselor, I think that your sister counselors may be suggesting there's a tension between the definition of conviction and the structure of subsection 2, where you're sort of looking back until you hit something, and it says then score that something, right? Mm-hmm. And so she's, I think, saying, well, if there's nothing to score there, then we should sort of keep looking back, right? I think that's sort of that structure of that section, I think, is what's animating her argument here today. Maybe you could respond to that.
And I get that's a similar question. I think that I don't see that tension. It basically, that is a gift, as far as, I shouldn't say gift, but a privilege or an entitlement. You've earned this. If you go without any convictions, then we will only do whatever post dates that 10-year gap, and then we only use these ones that we believe are relevant to determining an appropriate sentence. But that if you've not been truly crime-free, just a minor crime, that you do not earn that, and then you go back. So that minor crime may not be scored against. It may be. It could be that it's, you've got a major felony in that middle, or you have a minor misdemeanor. It certainly doesn't define, again, that's why we're here, because it doesn't define it. It just has any conviction. I don't see the tension. For whatever reason, it appears that there was some effort to strike a balance, and that's the balance that they struck. If you're reading it, it's really, it's clear, there's no ambiguity. There may be emotional ambiguity or philosophical ambiguity, but there's no actual ambiguity when you're sitting down with your pencil and trying to figure out what you can use and what you can't.
Counsel, would this be a basis for a judge to do a downward departure? Still look at all the variables, obviously, but consider, well, that one, it was a minor misdemeanor. Could they do a downward departure?
I don't see, I think you articulate the reason. I don't see any reason why a judge would not be able to go with a downward departure. I would suspect that downward departures are rarely appealed, but I think that would fit within the judicial ability for deviation, reasonable deviation, yeah. I can keep going through all the cases that we have. I don't really want to bore and waste the time, so maybe I'll save my last 2.5 for rebuttal.
You do not have rebuttal, so.
Oh, apologies.
It's okay.
Used to being on the other side.
Thank you very much. Appreciate it. And you have just under 2 minutes.
I just wanted to clarify what the prosecutor mentioned about empathy has no place. I think me mentioning the factors that make Mr. Boven's sentence disproportionately high, if it strikes a chord of empathy, that's fine, but these are factors that are relevant to proportionality in sentencing. The predictive value of a prior offense is low because you're weighing it against the fact that he was a contributing member of society, highly contributing member of society for 17 years, and that this minor offense, it was in 2011, so it wasn't like he offended the next year or even the next, it was
How do you
almost
respond?
10 more. Go ahead.
I think that you make a good point as far as it was 9 years prior, right? What if it had been just 1 year prior? It's the same offense, but it was 1 year prior. Would you be here before us with the same argument?
Yes,
Okay,
absolutely.
Okay, and then what if there were 5 or 6 similar, low-level misdemeanors that were not scored under the PRV?
Then I think that would be an issue for the judge to decide if he wanted to go higher or within the low range, because I think that the statute is clear that you don't go back and count these convictions that aren't countable. I think it's clear as well. The prosecutor thinks it's clear, but I think it's clear the other way, that they did not mean that to count things that aren't countable when they go back, when it's, the Section 2 instructing the courts on how to apply the 10-year gap. So you can't use a conviction if it's not usable. So they would have had to add something extra to indicate that they wanted people to score crimes that weren't crimes under the sentencing guideline manual.
Thank you. Thank you both. The case will be submitted.
Thank you.